Good lunchtime, everybody. It is March the 10th, 2025, and this is a meeting of the House Criminal Law Subcommittee. We do have a new member, Delegate Stinnett, who was just appointed, has been assigned to our subcommittee. So everybody, welcome our newest member. And with that, I will turn us to, I don't want to say one bill. We have one topic today, and it is theft of mail or porch piracy, however you want to call it. We had actually several bills on this topic. Delegate Conaway introduced several permutations of this to give us a series of options, and Delegate Tolles also had a bill on this topic, as well as Delegate Solomon's House Bill 805. And I just want to say from the top, I don't know which bill we are going to do the work on. This is not to prejudice any of the bills from Delegate Tolles or Conaway that I just mentioned. Um, but I'll say that in common, what they had was most of them were attempting to put a felony on mail theft, a 5-year felony. That seemed to be the common thread from that stack of bills. And Delegate Solomon's in HB 805 proposes a misdemeanor or felony on the basis of how many pieces of mail were involved. And I think the number they have is 16. So 1 to 16 is a misdemeanor, and 16 or more pieces of mail would put it into felony territory. And they also had the issue of a arrow key, um, which I guess they use to unlock the blue boxes and things like that, as an added issue for penalization. Um, and so we're just gonna look at Delegate Solomon's bill instead of the other bills because again, most of the other bills had as a common element trying to bring a felony provision in here, and Delegate Solomon's was cut up a little bit more. So Chris, if you wouldn't mind putting HB 805 on the screen so we can see what we're working with, I would appreciate it. And if you want to try and scroll to the relevant bit, I would also appreciate it.
If I could, while Chris is scrolling, Mr. Chair, if I could add, since I'm Delegate Solomon's district mate, the reason the arrow key thing is in there that we've had several mail carriers in our district held up at gunpoint for their arrow keys because that's what they use to open the mail. And then once they get the key, people can, take the checks that were in people's envelopes and, and try and cash them and things like that. So arrow keys are a big issue in our district. I hope that's helpful context.
Yes. And sorry, Chris, if you could scroll up a bit, back a bit, where there's the arrow key section begins. All right, do you want to keep going? Scroll a little bit. Keep going. All right, here we go. So it looks like this is proposing 6 months misdemeanor on the small amount of mail theft and a felony up to 2 years on a larger amount of mail. And I'm guessing the arrow key is a felony. Delegate Solomon is here. Delegate Solomon, do you want to, are we getting this right?
Yeah, Mr. Chair, thanks for the opportunity to be here, and I appreciate you all working on this. You're correct. I just wanted to sort of put out there. So this was, I think some of you remember, we brought this bill, a version of this bill last year, obviously with significantly higher penalties based off of longstanding precedent. And so we made some changes to it last year in the Senate. The Senate version came over, and we just weren't able to finish things with the timing during the 24 session. So this was a product of a work group that we put together, sort of informally, between Senate counsel on your committee, and folks from the state's attorney's office, and folks from the United States Postal Service investigative unit. So this is sort of what we came up with as something that we thought was reasonable, was graduated, and really got to the issue of the fact that just because you have a piece of mail, obviously it's hard to necessarily assess a value. But obviously, if you have a significant number of pieces, it's likely sort of more of a ring or a concerted effort. But I just wanted to throw out there that we're open to other modifications. I think we heard loud and clear from the committee last year that we wanted things to be reasonable, but also obviously this is a problem, so there needs to be some sort of a penalty. So there's no sort of ownership here over any of the penalty provisions if you all decide to do something a little bit different.
Can I ask which House members were a part of this work group?
Yeah, so it was really just myself and Senator Waldstreicher, and then the councils working through agreements between the two committees. Again, it was more of an informal sort of conversation based off the feedback that we got from the bill last year to try to come up with something that was again a little bit more representative of what we had heard from both committees.
And where did you come up with this 16 pieces?
Um, so I'm trying to remember if there was any sort of official threshold there, and I know Steve from the Postal Service is on as well. Steve, I don't remember if there was anything specific to the 16. I think we just sort of thought that was more of a reasonable number.
Yeah, no, I would agree with you. I don't, there's no federal threshold in that sense. I think it's just a matter of that was a place to split it.
Yeah, so Mr. Chair, I think we'd be open, again, if folks wanted to tweak that a little bit more, we'd be open to that as well.
One other question I have, and then we'll turn to Delegate Simmons. I'm looking at the fiscal note, and it says there were 18 district court charges for opening mail, zero guilty, and 20 and one in the subsequent year. Do we know anything about those 18 and 20 cases and whether they were of the type contemplated in this bill or if they might have been something else, opening a letter without permission?
That is an excellent question that I am not sure the answer to that. I don't know if anybody else on the call, if I don't know if we have anybody from the state's attorney's office on with us. Maybe you're.
We do. They may not know the answer to this question. Mr. Kroll, do you happen to have any info on these 18 or 20?
I do not, Mr. Chair. I'm sorry. I would be happy to get that for the committee, but I do not have any info.
All right, not a problem. All right, Delegate Simmons, did you have a question or comment?
Yeah, I just had a question about the enforcement piece of it. With the timeline, I was looking with the key. So why does not any language like the same as like strong arm robbery when it comes to if they're taking the key, if they're using force to take the key, and things like that, which is a penalty of 15 years in prison.
I mean, I would think they would be subject to,
Is this a combination of both of those,
yeah.
or separate? Okay,
I mean, this is a possession offense here, to be
right,
clear. So you would have them, whether or not you could prove the assault or what have you.
right.
And actually, Chris, would you mind putting up on the screen the fiscal note on page 2? There's a table. Yeah,
Okay.
we can stare at this bit right here.
And Delegate Simmons, there is a provision at the very end of the bill that says a sentence imposed under this section is separate and consecutive or concurrent with the sentence for other crimes. So I think this would be on top of that.
I got you. Appreciate it. Yep. Yeah.
Delegate Grammer.
Thank you, Mr. Chair. I'm trying to find the 7104. What I was trying to find how theft is defined there, and I can't find it in the bill. Can someone elaborate about how theft is defined?
I think this would be covered, the mail theft, but it's value based. You know, the value of the theft is this much versus whatever. I can't remember what thresholds are these days. $1,500 or whatever.
But what article is that?
That might be in 7104. I don't, let me see if I
I mean,
can.
is that criminal?
Yep,
Yeah.
Okay.
7104.
Delegate Sample Hughes.
Thank you, Mr. Chair. I'm trying to get my computer going, but I'm doing this on my phone. I just wanted to understand at the federal level, what is already the penalty? I know the gentleman's on here from the Postal Service. I'm just wanting to understand that piece.
So at the federal level, it's a felony across the board, and it's 5 years.
And that's no specific number of mail, and that includes the arrow key as well?
Well, barrel key would fall under theft of mail is one thing. Then there's theft of U.S. property.
Okay, so
And
we
so
at the state level are trying to make it a less of a crime?
I think what really the intention is to make it more palatable to charge this as, because the problem with mail of this type is there's no necessary value to it, but there is a value to the person of it. And so you want to impose some kind of penalty for it, but a felony seemed like an excessive penalty to apply for, lower amounts of mail. So there was a desire to give more variability in the state's options to, as far as mail theft was concerned.
Mr. Chair, can I say something in response to Delegate Semple Hughes? I think, and Delegate Solomon can elaborate, but I think in talking to the U.S. Attorney's Office, because of being under-resourced, they seldom enforce, they seldom prosecute cases like this. And Delegate Solomon can elaborate further if he's still on, but based on Delegate Solomon's conversations with the U.S. Attorney, despite what Delegate Semple Hughes outlined about how it's already done at the federal level, he felt based on his conversations with the U.S. Attorney that it was still necessary.
Yeah, I think if I gathered part of the rationale for this bill, it was to encourage local prosecution where the person might not otherwise be charged by the feds and, perhaps just sort of get away with a slap on the wrist.
That's correct.
Yeah, that's right. I mean, what we were told was that, especially for the smaller crimes, the U.S. Attorney's Office really only has the resources to go after sort of the ones you would see in the headlines of $1 million or more, and this was to give states attorneys and local law enforcement another tool to be able to enforce this. We also heard that even some local police departments are just sort of they won't do anything because they know there's not the capacity to prosecute this at the federal level. So this gives, again, local law enforcement more options to be able to go after this kind of stuff.
Okay, and one last thing, Mr. Chair. I guess my thought process is that it's always been, people have been nervous about doing anything with someone's mail or intentionally taking it because of the what they think are the penalties of a felony. So we taking it down to a misdemeanor might very well just be like, okay, well, nothing's going to happen really. But that's just my thought process. But thank you so much for the feedback.
Well, let's
Not right now.
why don't we let's see. Is there
I have a
anyone?
question.
Yes.
So I'm just trying to get clarity on this. So if they're charged at the state level, this prevents them from being charged at the federal level, or they can be charged at the federal level as well.
They can. They could be charged in both jurisdictions. It would be unlikely, though.
Say that again. I didn't hear you.
And I'm sorry to jump in, but yes, you can be charged for the same
Right.
intent federally
On the
and
federal level. Okay, so
but it's rare
concurrent.
because it would
Okay.
not be considered a good use of resources.
Okay. All right. Thanks.
So why don't we just quickly straw poll the three separate elements here? And it is felony possession with intent of an arrow key, 16 pieces or more felony, and use of arrow key felony. Does anyone object to any of those three items? A felony for possession with intent of an arrow key, a felony for theft of at least one item using an arrow key, and a felony for stealing over 16 pieces of mail.
And what was there any discussion as to whether they should all be felonies?
Well, this is the discussion.
No, I'm just saying, like, to me, it seems like if you have one of them, you're going to wind up being charged with all of them.
Right.
So, I understand what Delegate Sample Hughes was saying about, you don't want it to look like we're not doing anything, but,
Well, hold on. Okay, I guess the scenario then is what you're saying is they're already all felonies anyway, so they should all be felonies?
No, I don't think they should be. Personally, I think you can give people plenty of jail time without giving them a felony. Felony does other things to people. So I would just say maybe you could have a felony for whatever is the most egregious of those three. I'm just putting that out there as a thought. Or the most common. But it seems like you're going to be charged with all three of them because you're not going to get caught until you.
Well, this is only if you have the arrow key.
Right, I understand.
No. But I mean, if you don't have the arrow key, the bill's contemplating a misdemeanor, essentially.
Right. It's an enhancement, right?
I think it's 16 items or the arrow key.
Right.
Yes, correct. I mean, right. So we could just deal with the arrow key this year. There's another way.
Yeah. Yeah, I need to speak to them. Sorry.
Delegate Cardin, do you have a different feeling about the arrow key versus the number of pieces of mail?
I don't really have a strong opinion. I was just putting that out there because I get worried that felonies tend, if you have multiple felonies, just, I'm just looking at those sort of long-term impacts of that versus improving or stopping people from doing it. So I don't really have a strong opinion.
Delegate Grammer.
Thank you, Mr. Chair. So the felonies are related to kind of like the arrow key and I guess like kingpin mail theft. I mean, I'm not wed to anything. Does the bill sponsor have a feeling as to why he drafted this with a felony for these higher offenses?
Yeah, Mr. Chair. I mean, I can just say again, as we were having this conversation with our group over the interim, we wanted to reflect again. If you have over 16 pieces, that is I think it was in our conversations a much more concerted effort to, really do this at scale. And then obviously, if you're committing the crime with an arrow key, it's not just sort of like a one-off. I'm taking this out of somebody's mailbox. You've taken federal property and you're opening mailboxes with that, like you're opening the blue boxes where people are depositing their mail. So it's a much more concerted effort. And again, I think this was our response to the feedback we got from the committee last year to make sure that these were graduated and a little bit more reasonable, in line with federal penalties. Obviously, with the caveat that we know for issues of this magnitude that tend to be smaller, those don't usually rise to the level of federal prosecution. But again, I think we're open to whatever the committee wants to settle on. And I believe the version of this bill that passed the Senate last year had something sort of similar to this as well.
So hearing that, I mean, if this is for the higher offenses, can we add these offenses to the list of expungible offenses in this bill? Would that satisfy Delegate Cardin?
I think, again, there ought to be some, if somebody has reformed themselves, I don't want this felony to be a scarlet letter. That's all I'm saying.
If we add it to the list of expungible offenses in this bill, does that satisfy you?
Yes.
Mr. Chair, can I make that motion that we?
Wait. Hold on. Let's not be doing things like
But
that.
I am.
A question. Go ahead.
Let me also say this. I'm not necessarily like, I think that is a larger discussion in terms of what and which ones are we talking? Let me say that I'm not that concerned. I'm not as familiar with all of these different types of instances with this key, possession of it versus use of it. The only thing I've learned is what we've just spoken about. So.
Yeah, and I think this is a great conversation, and I think this is the kind of thing we should do every time we debate a new criminal offense. Like, we should think about it soup to nuts. But what the bill sponsor is telling us here is, like, these are higher degree offenses that would typically rise to the level of a prosecution when frequently they wouldn't see any prosecution. So these are like the real bad actors. So this seems to be the simple fix to me. These criminal penalties aren't really long. Let's be honest, most people aren't going to get the full penalty. And if they got the full penalty, it's going to be significantly reduced. So, I mean, if anyone wants to make a different motion, I think they can. But I think the simple thing here is probably to add language to this bill, adding this offense to the list.
I think that this is premature. I don't think we should be talking about expungement now, to be honest. I just don't think it's.
I would like to float a proposal. What if we don't get into the malarkey of choosing a number like 16, and we just make theft of mail, we just up the penalty on theft of mail to be a misdemeanor up to 2 years, so that it's just all discretion, but it's up to 2 years misdemeanor on theft of mail, and the arrow key stuff can be the felony.
Okay, Mr. Chair, I think I like that. I mean, my concern is that somebody has the nerve to go and steal the arrow key. We're talking about when you go to apartment complexes and the mail person is there to put the mail in the mailbox. You have access to like 15, 20 or so odd residences.
Yeah. No, and I'm saying we would make that a felony.
Right, and I agree with that. And I personally think that this bill in particular just needs to focus on the arrow key, give it a felony, and then keep it moving. But certainly I understand where you're coming from to address two parts of it.
Delegate Boucher and then Simmons.
Thank you, Chair. Yeah, I like what Cherie just said. I'm a little bit hung up on the arbitrariness of the 16. I think it should be connected to if one of the checks was, or one of the items of mail was a check and there's a monetary value. because I think the threshold of felony has to be connected in some way with a monetary substance. I mean, if someone stole just, 15 pieces of arbitrary mail hoping to find a check is different than if they obtained a check. So I'd really like to have the felony side of it connected with some sort of value. Thank you, Chairman.
Mr. Chair, can I just respond to that for a second?
Sure.
Delegate Boucher, I understand your concern over that. The one issue that I will push back on is it's not always just checks. Somebody could take a piece of mail that has a social security number or personally identifiable information, and the issue is more, and I know Steve from USPS can talk a little bit more about that. It's really difficult to put we had sort of gone down that rabbit hole a little bit in our initial conversations, but it's really difficult to put monetary value on personally identifiable information. Does the value kick in when somebody steals your social security number and opens a credit card in your name? A check is sort of one thing, but I think we were more concerned with the information that somebody could be taking from the mail and what they could be using it for, which is why we went more in sort of the number of pieces as opposed to the value attached to each individual piece, because that's a little bit harder to assess.
I sincerely appreciate that explanation. I'm always just very concerned about judicial review. If this gets hung up, if someone appeals a conviction, what they'll do with it. I just want to make sure we don't get hung up and whatever we produce goes through the judicial system smoothly. So thank you very much.
Well, what do you think?
Right, Delegate Simmons and then Grammer.
I'm just trying to get a better understanding of how big is the problem here.
Aaron, your mic is on.
I'm sorry. Can you hear me now?
Yes.
All right. So I was just trying to get a better understanding of how big is the problem here in the state of Maryland. Kind of, do we have any numbers, stats, data around that? And if so, what areas do we see an increase or large numbers as a result of this crime?
Yeah, and it's hard to tell. I mean, the fiscal note numbers are fairly low, but it seems like anecdotally I hear about a lot more than you'd think there were 18. So there's either some number of cases not being captured in the fiscal note, or the news covers it more than, makes it seem like there's more going on than there is.
Mr. Chair, the only thing I will add to Delegate Simmons' question. Delegate Simmons, we were told it's sort of, to your point, it's hard to sort of know the exact numbers, because we were flat out told by the local police department in Montgomery County that they will not even really investigate a lot of these issues. They turn, sort of the arrow key piece, because that's a bigger deal, over usually to the USPS. But when it comes to just mail theft, unless it's something that rises to a really, really, really large number, they don't even pursue it, because they know the U.S. attorney just does not have the capacity for it, and there's nothing for the state's attorney to be able to prosecute under.
So if I'm a mail carrier and I get assaulted, the key get taken, I call the police, local police come, they don't deal with it at all, or they refer it to the federal government? Like, I don't understand the steps.
Yeah, and Steve, if you want to jump in more on that, obviously, if you're held up at gunpoint, I know they would investigate that. But the actual theft of the arrow key piece, I'll defer to Steve.
Yes, you set out a situation that has a lot of layers to it. Like in that situation, that's not going to just be where there's an assault and there's a theft of an arrow key and that kind of thing is likely to be investigated by the inspection service directly, oftentimes in concert with locals, but or even a theft of an arrow key, because the potential for, and it's similar to what Delegate Solomon had mentioned regarding PII, is the arrow key is far more than just one blue box. It has the potential to open up multiple blue boxes, multiple apartment boxes, multiple things like that. And so if the arrow key gets lost, then we or stolen, then we have a strong desire to go and get that back, and then to pursue it federally. But
sure, my problem is that, like, there's a lot of empty information, right? I don't know what numbers, I don't know how big the problem is. I don't know the number of investigations that took place and who it took place by. What's the results of those investigations? It's like grasping for straws here. I'm getting more confused as I'm listening to the conversation. My thing is that, as we're looking at imposing laws, it has to be grounds for it. So is it one person in Montgomery County? Is it 12 people in Anne Arundel County? Like, how do we track what's taking place that make us want to do a statewide, legislation for enforcement with penalties, right? So that's my question is, I'm not understanding how we at this point if nobody got any data to how we got here.
But I can, if it's helpful to you all, I can reach out to our Washington division to see, to get a representative from them to really go over the mail theft.
Yeah, we need more information. I would think that we would need data. We would need some idea of where is this taking place, throughout the state of Maryland, because that may be something that we need to focus on with those jurisdictions. And, we're turning over now a federal crime to our local state or local departments, that is an issue too, right? So, my thing is, why are we proceeding in this manner, based on what?
All right, let's go to Delegate Grammer, Kaufman, and then Embry.
Yeah, thank you, Mr. Chair. So Delegate Simmons has a great question, but I think Delegate Solomon said the magic words. These are not going to be investigated if it's not a felony. And we hear that with different crimes all the time. So if you just envision this, if this is happening in your community, you might get a police report. These numbers might not even get registered. And we've heard this issue year after year after year. I'm looking at the penalties. That seems to be the big debate here. The bill sponsors got pretty articulated the need for this penalty structure. And if we're stuck on the number 16, like, keep in mind, if you're going to prosecute that crime, that means you need to be able to prove that person stole at least 16 pieces of mail, which could be all this personally identifiable stuff, which is critical, but it also could be packages that are worth hundreds of thousands of dollars. So, I mean, I'm pretty comfortable with the bill. I'm good with moving it at this point.
Delegate Kaufman, and then Embry.
Yes, I agree with Delegate Grammer. I'm comfortable with moving it and would prefer that it be clean, but to get the votes, if it needs the Moon Amendment that you were suggesting earlier, I'm in favor of that too. I just think we need to move it this year. And I understand delegates' concerns about the lack of data, but I think Delegate Grammer's right that if it's unlikely to be prosecuted, then we're not going to have as much data because not a lot of effort's going to go into, recording these matters. And I think that, I can just tell you, and that it's been such an issue, Delegate Simmons, that it was a subject of a Washington Post article a couple years ago that I can send you. So it is a real problem. And I'm comfortable moving the bill as it is or with the Moon Amendment. I just think it's imperative that we act on it this year.
If you want to move it, I'll second you, Aaron.
Okay.
No. Let's keep going. Delegate Embry.
Thank you. And I'm comfortable, like Delegate Kaufman, with the bill as is or with your amendment, Delegate Moon. The only thing I wanted to add is one of the reasons I like this bill is Baltimore City, like a lot of other places, has enormous amounts of package theft. And this gives an option for where you don't really know the value, or maybe it's a very low value per package. So it gives you an option where you're not limited just to value, but you still have the option, of course, if it's a high value package, to charge theft, felony theft based on that amount. So I think this is a useful tool. Putting aside the arrow key, I think it's useful to have the 2-year penalty, whether it's a felony or misdemeanor, for theft of mail. Thank you.
Thank you. And let me ask, I think many, if not most of you were on the subcommittee when we took up facial recognition. I want to throw a curveball question at you folks. So you remember when we authorized a list of crimes for which facial recognition technology may be used? I had wondered, in light of many of these crimes being caught on Ring cameras and what have you, whether we want to consider putting if we put this state mail theft crime in there, if we want to authorize it as a facial recognition crime.
I'm fine with that.
I'd love it.
That is brilliant.
I don't think we did any theft last time, so this is a pushing it into lesser crimes, but I just kind of think this is one that might actually be solvable. So it's
Great
interesting.
idea.
That might be
I'm
the
okay
only
with
way
that.
it's solvable.
Delegate Stinnett has not spoken yet. Would you like to say something?
Yeah, I'm just curious, and I know that, of course, I'm coming in late and trying to play catch up, but I'm just curious about 16. How do we come up with 16 items as the number? That's, to me, that's just an awkward number, but I know there's a meaning behind it.
Yeah, again, Mr. Chair and Delegate Sinet, it was just sort of a reasonable. There was nothing sort of attached to it in our conversations, and again, the penalty provision structure here is fairly similar to what passed the Senate unanimously last year. Again, in those negotiations, as we were trying to figure out path forward on the bill in the last session. So we started with that premise when we got to work again on the bill during the interim. So I think it was just sort of up to 15 we thought was reasonable for the misdemeanor, and then again over 16 the assumption was that this was much more of, or 16 or over was much more of a concerted effort to do this as opposed to just sort of one off.
Okay, thank you, Mr. Chair. Thank you, Delegate Solomon.
So, all right. It sounds like everybody's fine with the felony on the arrow key provisions. And it sounds like everybody's fine with the curveball addition of authorizing facial recognition technology for the mail theft crime. I just want to poke one more time on this issue about the 16 pieces and whether we want to get into this business of setting a number of mail pieces threshold here. And again, the alternative I would put up is we don't get in the business of counting, and we just say if you steal mail, it's up to 2 years, misdemeanor up to 2 years. And we breach the felony line with arrow keys this year, and we can come back another day and look at whether we want to do just pure theft of a mail piece as a felony.
Bill sponsors made his case. It's a high bar. I say we let it roll.
Chair, I'm in agreement with your last statement in reference to the 16. And I'm not clear on that number either, and I haven't seen anyone truly articulate it. So, yeah, I'm in agreement with you on that.
Delegate Bartlett.
Yep, I'm on board. Just wanted to, because I hadn't said anything. I just want to let you know I'm on board with that. The 16 is weird.
Does anyone object to this direction? We would do up to 2 years misdemeanor for stealing mail, a new state crime of mail theft. We would make that crime authorized to be investigated by facial recognition technology, and we would put a felony on arrow key possession with intent or use of an arrow key for theft of mail.
Outstanding.
Second.
Well, now
I'll
hold
object.
on. I want to have this written up, but I need to go back to the chair as to which bill we're going to put this on. So this may be a stay tuned. We'll either pull this all up in full committee and do it there, or we'll just put it back on this bill. But I just need to pause because again, there were multiple members that had bills on this topic, and I pulled Solomon's out of the stack because it had a few more pieces that we might wanted to discuss. So with that, and I think that's why Delegate Tolles had her hand up. So it looks like it's down now. So with that, I will say, unless anyone has anything else they want to add.
Thank you, Dave.
Yes. Delegate Grammer, is your hand still up for a new comment? No.
I'm good.
All right. So we'll have this written up. I'll talk to the chair, and then we will take action on what we just said in some form at some other time.
Okay. Mr. Chair, this delegate sample use, just one quick question for you. So the Tolles and Conway, they were both felonies on taking mail, period.
Yes.
Okay, thank you.
Yes, so they were a bit more
Mm-hmm.
they were seeking a more harsh direction, I think, but I
I
think we're
agree.
landing generally in the direction people are trying to go.
Okay, thank you so much.
All right, see you all next time.